Hello and welcome to episode 50 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh LaHaws, counsel with the Canadian Constitution Foundation.
I'm Christine Van Geyn, the CCF's litigation director.
And I'm Joanna Barron, executive director of the CCF.
In today's episode, I'm going to tell you about the not guilty finding related to two men accused of conspiracy to murder police in Coutts, Alberta during the Freedom Convoy.
I'll tell you about an Ontario farmer who's being told that he needs to pay up to the tune of $400,000 in archaeology fees if he wants to build a house on his property after certain artifacts were unearthed.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I want to tell you about a counter-protester who stood up against Hamas supporters and got arrested for it, and explain why I think that decision by police may have violated his rights. So I'm talking about Dominic Carty, who is both a former New Brunswick NDP leader and a former New Brunswick Progressive Conservative Education Minister, which is interesting. He's currently interim leader of the Canadian Future Party, which is an upstart centrist conservative party related to the Centre-Ice movement. And it's not actually all that important who Carty is. What's important is what happened to him last Thursday in Toronto. As he recounted on X, Carty was visiting Toronto when he heard a bunch of chanting at Sankofa Square, coming from what he described as a bunch of Hamas enthusiasts. And I think that description is warranted. Now, these protesters were blocking traffic, and they were literally trampling on an Israeli flag in the middle of the intersection, chanting things like "Long live the resistance," and these are not nice people. Carty waded into the crowd. It wasn't a huge crowd, but he waded in. He started chanting in the middle of it, "Free Palestine from Hamas, free Palestine from Hamas," which obviously these people did not like. As he puts it, this attracted negative attention, which is fine, he says. He says, quote, "In democracies, we have our voices and our bodies, and all expect both to be protected when we exercise our rights. As we live through this horrible reboot of the 1930s, we have to use our rights to resist the authoritarians." Carty adds, "I was approached by a Toronto police officer. He asked me to leave. I declined. He left. I was met with multiple threats and a good kick from assorted masked weirdos." And then you can see in a video posted by the lawyer and journalist Karim Assad that there are various people, including at least one keffiyeh masked thug, physically intimidating Carty. They're yelling at him. One woman makes the upside down triangle. I don't know how to do it. That's a rectangle. Upside down triangle with her fingers. Yeah, you got it, Chrissy. I failed kindergarten. Just She makes this upside down triangle symbol, which is obviously a reference to the red triangle from Hamas's propaganda videos, which shows who's their next Israeli target.
Disgusting.
Yeah. And, it's tense, like these protests with counter-protesters always are, but I didn't see Carty do anything that looked violent or threatening, and you never know, but you can't see it on the video. Anyway, police returned and arrested him for disturbing the peace. He says he was staying at the police station, locked up, where he took a nap, and he was released after a couple of hours without charges or conditions. So he writes on Twitter, "No more standing by. It's time for standing up. Step up against extremism. Defend our open society now." And he says he refused to agree with police that he wouldn't attend future protests. So I've reached out to Carty to try and discuss this situation because I want to know if there are more facts that we're unaware of. Because, based on what I saw, it looks like his rights were probably violated by the police. I don't think he gave them any reason to actually believe that he was about to breach the peace or that he had breached the peace. And so this is why I'm concerned. And I say this based on the law as outlined in the 2019 decision in Fleming in Ontario, which is a case the CCF intervened in to defend a protester whose rights were also breached. Randy Fleming, just to give the background of the story, was a resident of Caledonia, Ontario, which is a town where Six Nations protesters were terrorizing the local non-Indigenous townspeople for years because of plans to build a housing development on land that they claimed they had been promised by the Crown. And this involved requiring residents to show Six Nations issued passports to get to their houses. There was a brutal attack on a man at the development with a 2x4 that left him with serious brain damage. There was more than one arson. At one point, a power station was burned down, which caused a big blackout. It was a really ugly situation. And rather than enforce the law, the Ontario government, which was Dalton McGuinty's government at the time, just purchased the site and handed it over to Six Nations to end all of the acrimony. Anyway, Fleming was a counter-protester, so he attended this rally called a flag rally, where local residents would just walk along the streets of Caledonia in front of the development, carrying big Canadian flags. And on the day in question, a police cruiser, 2 vans, and paddy wagons all sort of aggressively approached Fleming, which caused him to walk up toward the development site. And he was carrying his flag, and police were yelling at him, drop the flag. And he refused to drop the flag, so they ran up and arrested him. And they put him in jail. They injured his arm. And he was arrested basically just for protesting with the Canadian flag. So the OPP went to court, and they argued that Fleming's rights were not violated because they'd arrested him basically for his own protection. They said someone else was about to breach the peace because when he walked up, there were, 8 or 10 protesters walking towards Fleming, and so they had to arrest Fleming in this scenario, even though there were, several cops available to confront the protesters if they needed to. So anyway, the Supreme Court, in this scathing 2019 decision written by Justice Suzanne Coutts, said this is not acceptable police behavior. It's a violation of rights. The courts do have the power to do what's reasonably necessary to carry out their duties, which include the duties to prevent crime, to protect life and property, and to keep the peace. But they don't have a power to arrest somebody who hasn't committed an offense, who's not about to commit an offense, who hasn't breached the peace, and who is not about to breach the peace. They can't arrest someone just to prevent a breach of the peace by someone else against that person. So anyway, the court struggled a bit to define breach of the peace, and that's understandable because it's kind of a weird concept. In one sense, originally all of the crimes were breaches of the peace, but then we started codifying crimes, and what we're left with is this more ambiguous concept that's not actually a crime, but it's still part of the law. And the criminal code says about breach of the peace that an officer is justified in arresting any person whom he finds committing a breach of the peace or believes on reasonable grounds is about to join or renew a breach of the peace. But all this means is the cop himself or herself is not violating the law when he or she arrests somebody for breaching the peace. It doesn't say it's actually a crime to breach the peace because it isn't a crime. And so this creates this weird situation where police can arrest people without, charging them with anything. And the court looked into various situations to try and define what breach of the peace really is. And they said, quote, violence lies at the core, and there must be a risk of harm and violence. They also said danger to the person is always involved, so it's not about property. And they said behavior that, quote, is merely disruptive, annoying, or unruly is not a breach of the peace. And if, basically what they're saying is if it looks like somebody's about to, punch someone or kick someone or start a riot at a protest, which are all actually themselves crimes, police can choose to take the sort of intermediate step of arresting for breach of the peace or anticipated breach of the peace, so they can, let that person cool off without actually charging them with something like assault. And that's sort of how it functions in our system these days. So the court also made clear, though, that police, like I said, can't arrest somebody just for being a provocateur. They say a provocateur whose lawful actions or words are feared to be prompting others to respond violently, such that they may become a victim of breach of the peace, can't be arrested because that would significantly interfere with their liberty interests to arrest them. It's also a violation of the right to be free from arbitrary detentions. Physical liberty is involved, security of the person, because you're physically grabbed, might be involved. And of course, according to the court, freedom of expression is involved because you are allowed to be a provocateur. You have a right to speak, even if it's provocative. So another little wrinkle in this, which is interesting, is that the SEC said that there may be truly exceptional circumstances where police may be allowed to arrest somebody who's not about to commit a breach of the peace in furtherance of their duty to protect life. And they said this would only be in exceptional circumstances. For example, in the hypothetical situation where a person's done nothing wrong, but an angry mob is about to attack them while they're lawfully exercising their freedom of speech, and the person refuses to comply with a lone police officer who's on the scene. So this is not what happened in Fleming. There were, at least 5 cops. There were about 10 protesters. So the court was like, that's not okay. You can't arrest someone in that scenario. And so they didn't have to decide whether that power exists, but it might. So long story short, if somebody's done nothing wrong nothing that gives police reasonable grounds to believe they're about to commit violence, then they could arrest them for breach of the peace. But reasonable grounds is not the lowest standard. They do have to have some level of evidence that goes beyond mere suspicion. So, for example, if somebody's running towards someone else with a pitchfork, police can probably arrest them for breach of the peace. But if someone's merely exercising his or her free speech rights, saying provocative things as a counter protester, and there are multiple cops available to arrest people if things do start to go south, the cops have a duty to protect that person's speech rights, and they absolutely should not be arresting them. And if they do, police should not be surprised if they face a charter challenge from someone like us. And, the CCF would be interested in potentially taking on one of these cases one day, because police do these things far too often. So anyway, I'm trying to get a hold of Dominic. If you're listening, we should chat. Please give me a call. I think that's all I want to say about that. Joanna, what's your reaction? What do you think after hearing this story?
Well, thank you for giving the breakdown of Fleming. I think Fleming is a really important case. And my reaction to the Carty situation, while I agree that it's important to sort of give operational deference to cops, and obviously a term like breach of the peace is sort of intentionally somewhat vague and allows a lot of operational flexibility. For me, it's just there were so many things the cops could have done if what they were concerned with doing, which is what, giving them the best faith interpretation. There's also a less good faith interpretation available in this particular situation when you have someone like Dominic Carty, who I'm sure the cops didn't know, but is like renowned for being very centrist and very sensible. And then you have people jumping on the flag of an OECD country in the middle of downtown Toronto, but all of which is to say there's so many things that they could have done to de-escalate that don't involve arresting the guy and making him take a nap in a lockup. Like, that is a very severe infringement of liberty. They could ask to have a certain amount of space. They could, like, the cops' job is to kind of put their bodies in between two hostile groups. And so it just seems to me to be unreasonable that they went to this extreme. However, as you said, there's a lot that we're not aware of. We don't know exactly what went down, but we also haven't heard anything at this point that suggests that there was a need to take Carty into custody. And it's important to get these things right. These things where people are literally losing their S on the street right now. It's important that Carty is right, that as much as I'm not much of a street protester myself, democracy requires that you use your voice and your body. And he has every right to show up and express his views in, what did you say it's called? I actually hadn't even heard that yet. And I have lived in Toronto my whole life. What's it called now? Sanofi Square?
Sankofa Square. They just renamed Young Dundas Square.
What's Sankofa?
You didn't hear about,
I heard that they were changing it, but I didn't hear they landed on, what's Sankofa?
Sankofa is, I forget what it means. It means something about looking back at your history and like atoning for it. And It's from the Akan people, which is a Ghanaian people who themselves were very involved in the slave trade. So it became this whole controversy because basically people were saying we need to rename Young Dundas Square because Dundas was was pro-slavery, and that's not actually true. He was anti-slavery, and if you know anything about the history and review it, he was instrumental in getting rid of slavery sooner than it would otherwise have been abolished. So the irony that they decided to choose the name of or a word from a language derived from a people who also participated in slavery around the same time is kind of lost on people. But anyway, we don't need to get too
Yeah.
deeply into that.
Anyways, I'm impressed by Cardi and his wife. When I read about this over the weekend, or partner, I'm not sure what it is. I started looking at both of their social medias, and they are like a very, very principled and brave New Brunswick couple. His wife has gone to Ukraine. She does various international aid stuff. She organized the like hand holding, encircling the synagogue that was attacked in Fredericton in January. So they seem to me to be people that we want to encourage and not lock up for their bravery. What do you think, Christine?
That's awesome. I want to meet these people. And
Yeah.
also, Joanna, don't forget, you say you don't engage in street protest, but I do recall being in Ottawa with you when a group of Hamas loving protesters were outside a conference that we were attending, and you did
I gave
counter
him the finger.
protest. So you're lucky that you were not arrested for your provocation. Also,
That is true.
another thing I just think is like so absurd is that um the notion that saying free free Palestine from Hamas is like should not be considered a provocative statement. Like literally we should free Palestine from Hamas. It's a terrible terrorist organization that's doing a huge amount of damage. The idea that that is provocative enough that we need to lock this man up is completely
My
outrageous.
God. Yeah. Like I was just reading, maybe we're going on too much of a tangent, but I was reading David Remnick has an amazing profile of Yahya Sinwar in the New Yorker this week. And he talks about how his nickname, even among Palestinians, was the Butcher of Khan Yunis, because he just established himself as just being like just completely brutal. Like he heard that there was a barber in Gaza that was like letting his customers look at nudie magazines in the back or something. Like he just heard a rumor and he like butchered him with an axe himself. And like these are things that are like not disputed. Like
Yeah.
these are not people that are going to liberate the Palestinians, guys. These
Yeah.
and
So I
the reason Sinwar was released from prison was because he had only murdered Palestinians during the Gilad Shalit prisoner exchange. He hadn't murdered any Israelis. So it was like, well, let me see how that turned out.
Yeah, I mean, it's just not a provocative statement. It's a completely rational statement. And the fact that it's considered provocative is kind of a condemnation of the people who were engaging in that protest in whatever that square is called. I mean, that their perspective is completely warped. Anyway, let's head to my news headline. So I'm going to give an update about a criminal law case, which to be clear, we are not involved in. And I add that caveat because obviously, as all our listeners know, we were instrumental in the legal challenge to the Emergencies Act in response to the 2022 Freedom Convoy. And this is a criminal charges and a criminal case related to one of the blockades, in particular the blockade in Coutts, Alberta. So these are the criminal charges. The case involved two men who were charged related to that blockade at Coutts, Alberta. It was one of many blockades that took place across Canada at the border locations. And the two men were named Anthony Oleanic and Chris Carbert. And they were charged with a variety of criminal offenses related to the blockade. And they were charged after the RCMP seized weapons, body armor, ammunition, all in trailers near the blockade, along with a firearms license in Carbert's name. And the police later located weapons, buckets of ammunition, and two pipe bombs at Oleanic's home. So the charges that they brought against these two men were mischief, possession of a weapon for a dangerous purpose, charges against Oleanic in particular for possession of the pipe bomb, and the most serious charges were against both of them for conspiracy to commit murder of those RCMP officers. So it was on the last charge, the conspiracy to commit murder, that the Crown overreached. They were not convicted. This week, a jury returned a verdict of not guilty for that conspiracy to kill police, but they were convicted of the other less serious, but I would say still serious, just less serious than conspiracy to commit murder. They were still convicted of those other offenses. So in reading the case, I learned a lot of details that are kind of like out of Hollywood. And I don't know if you guys are aware of these details, but they're pretty out there. So the Canadian press described the case as a story of femme fatales, government conspiracies, the devil, and an armed invasion leading to a dystopian future. So, like, I don't know, tell me more, Canadian press. So apparently, in support of this charge that Oleanic and Carbot had conspired to kill police, the Crown presented evidence of three female undercover cops who had posed as volunteers during the protests, and they befriended Oleanic. And they testified that Oleanic had spoken extensively about having a cache of guns and ammunition. He talked about how much he hated the police. Apparently, Oleanic told one of these officers this was his destiny and the war he was supposed to fight in. And once again, that he was going to die for this fight. And he said, apparently, to this officer, he wants to kill them all. And the officer testified, this undercover officer testified that Oleanic likened Prime Minister Trudeau to the devil and called the compliant Mounties the devil's arms. And he told the officer that he did not expect to survive the blockade. So Oleanic's, this was a lot of these were by text exchange, and Oleanic's lawyer accused the undercover cop of flirting with Oleanic, responding to his texts with heart emojis. And then they got into a debate about whether a heart reaction is about you like loving the message or loving the messenger. And the lawyer said, it should have been apparent to you that Oleanic was beginning to be interested in having a relationship with you that was beyond friendly. And the officer said, I didn't feel that way. That wasn't the impression I was getting. And then in a videotaped interrogation by police after his arrest, Oleanic said that he and his comrades only wanted to play the role of protectors of the people in Coutts, and that the goal was to take a stand against the takeover of Canadian freedoms by tyrants, including the United Nations and Chinese communists. So a lot of stuff there, but don't worry, it was not just Oleanic. There's lots of drama related to Carbot, who is a self-proclaimed prepper. If you don't know what a prepper is, there's a really good show on Netflix that describes like how to be a prepper. It's pretty cool. You basically are preparing for the apocalypse. So people have different prepper styles, like they'll stockpile different types of things depending on what type of apocalypse they're anticipating. Recommend this show about preppers on Netflix. It's pretty interesting. Anyway, he's a prepper, and he told the court that he was prepared to head to the mountains and do whatever was necessary if someone tried to vaccinate him. And apparently he texted his mom saying, Mom, I am fine. If they start the violence, I'm just telling you there will be war and casualties of war. I don't think you truly understand what this is for and about. If we lose here, I will likely die in the war. So, wow. He also admitted to bringing a restricted weapon called a Panther Arms AR-15 assault rifle to Coutts, which was then seized by police, and he described the police as losers and the enemy. But he later said that he was embarrassed to say that. He said it was dumb and he regretted calling the police losers. Okay. Well, anyway, the jury found them not guilty on the conspiracy to commit murder charge. And the CBC reported that when the not guilty charge was read out in court, there was a loud gasp. And then someone later outside yelled freedom. And obviously, this is some wacky stuff. And the weapons charges they were convicted of, as I said, while less serious than the conspiracy charges, are still serious. But basically, I think that the conspiracy charge was overcharging. And we've had some debates online with a particular academic who said to me when I raised concerns about a totally unrelated issue, I was concerned about Bill C-63, which relates to online harms. And I said one of the problems with giving these really high charges is that the Crown can overcharge in the hopes of getting a plea deal. And it looks to me, and it looks to other observers, that that's what happened here. That the charge of conspiracy to commit murder was an overcharge to create pressure to to lead to a plea deal, which ultimately didn't happen in this case. But it kind of just shows the point that yes, the Crown does overcharge, and giving like really high the potential to bring really serious charges in C63 is an issue because Crown does overcharge in order to get leverage to do a plea deal. So I mean, like, I'm bringing in a personal grievance now with this academic who said that doesn't happen. Maybe don't take advice of academics about like what actual practice of law is like, because sometimes they don't know.
Mhm.
Um, so I'm not the only one who thinks this was an overcharge. Oleanik's lawyer said, I never believed since I took this file that there was evidence that would support a finding of guilt on the conspiracy charge. So it's always a tremendous relief, but it's not surprising. We had a thoughtful jury that took plenty of time to think it over. And Carbett's lawyer said, I think it was an overcharge to begin with, and I'm glad they came back with the verdict that they did. So I don't have much more to add than, wow, I did not know about all of these like femme fatale undercover protesters and like all of this drama related to the case. Maybe I'm gonna have to rethink heart emoji reacts to things because apparently that's flirting. Um, that's what the allegation was here. But I don't know. What do you think, Josh?
I think it's super interesting, and I'm glad you talked about it. Well, first of all, this is a very minor point, but you mentioned that body armor was found, and I've been reliably informed that it was not body armor; it was just a tactical vest that anyone can buy at Canadian
I
Tire.
see. Okay.
So, small minor point. This what happened at Coutts, like this particular case with these two guys, it's the most serious thing that happened during the Freedom Convoy, and they faced really serious charges, and so everyone sort of walked away with the impression that like, oh, some bad things happened during the Freedom Convoy. Well, the most serious charge nobody is actually convicted of because it was overcharging. And the other point is, Coutts is one part of the country, it's in Alberta, and the Emergencies Act is very clear that the threat can't, for it to be a national emergency, it has to seriously endanger the lives, health, or safety of Canadians and be of such proportions or nature as to exceed the capacity or authority of a province to deal with. And in this particular case, Alberta's RCMP completely dealt with the situation at Coutts.
Yeah.
So, from a federalism perspective, you basically have the federal government saying, hey, Alberta, this is a national emergency. Alberta is saying, no, it's not. We don't need your help. We used our own RCMP because the RCMP in Alberta are under contract to the province to deal with this, and they did. And it's just like Windsor, where Ontario police, they dealt with the situation there, which was also serious, but the police were able to deal with it at the provincial level. So not a national emergency, even though some relatively serious things did happen in Alberta specifically. So that's all I want to say about that. Joanna, what do you think?
Well, I just have one question. Was the emoji hearts, was she tapping on that? Was she reacting with hearts on the message, or was she sending actual hearts as a message? Because that's two completely different things.
It wasn't clear from the reporting. It seemed from the reporting to me like she was doing a heart emoji react,
Oh,
which
okay.
I don't think is
No,
flirting.
no, that I
Otherwise,
do.
it's flirting
I
a
do
lot.
like, I do to like our board chairman. Like I do it all the time, to my dad.
You
But like
harlot.
sending a row of hearts, that is different character.
Sending standalone heart emojis is I do think is flirting. Heart
Yes.
reacts, I don't know. So I actually am not sure. It seemed from the reporting like it was a react emoji, but I don't know.
Well, then
I'm
that is definitely, throwing the ball too far. But yeah, I mean, the mens rea for conspiracy is that you have to have crystallized a plan in your mind, and that's kind of difficult for the Crown to prove. But it's interesting that they chose the honeypot method of
yeah.
going undercover and getting, although that has been argued to be more reliable than the Mr. Big approach. So where they would have like sent in some like gangster who's like, I'm high up in Diagolon and I can help you. Then there's like more of a motivation to start boasting and start saying things that are going to be even less reliable. So actually,
Well, definitely men never boast to impress women.
yeah, yeah. I mean, the risk is there in either case. But anyways, this sounds reasonable to me. I mean, look, these guys were caught up with some sketchy stuff. That's the weapons cache. That's pretty cut and dry, but I don't really know. I guess you alluded to the reason, but it seemed unwise for the crown to overplay their hand as they did. So let's take a break and we'll come back and I'll tell you about the sad story of a Waterloo farmer who turned out to be sitting on rare historical artifacts on his property. Okay, so we want to talk a little bit about this story of a farmer in the Waterloo region named Bruce Castle, who has been quoted about $400,000 in costs for a publicly, provincially mandated archaeological assessment. So he's been told by the Ontario Minister of Culture and Multiculturalism that he will be fined or possibly even jailed under a violation of the Ontario Heritage Act if he disrupts the artifacts that have been found on his land. So this started more than 4 years ago when Bruce decided to develop a field on his property that he used to farm. And he wanted to build a house there. He's 75 years old and he wanted to build a house for him and his wife to retire to. But first, he was mandated to get an archaeological assessment of the land. And so the first archaeologist he hired did a first stage assessment and a second stage assessment. And he was given a budget at the end, which totaled about $400,000 and included fees to consult with relevant Indigenous groups. And the reason is that at the stage 2 assessment, archaeologists identified 134 pre-contact Aboriginal artifacts, or I suppose Indigenous artifacts, including scrapers and projectile points in an area of the field. And the archaeologists assessed that the site was interpreted to be, and this is just interesting in general, I mean, we'll get to what it means for Castle, but this was interpreted that this land was at one point used as a large area of temporary seasonal occupation by Indigenous communities throughout the Middle Archaic period. So that's 6,000 to 8,000 years ago. And the report says that hunting and hide processing were undertaken at the site, as well as the production and maintenance of formal tools and projectile points. What are projectile points? Is that like a weapon of some sort?
Arrowheads.
Okay, cool. And they also found, about 15 meters away, the archaeologists found 12 pieces of Onondaga chert chipping detritus, which they used to identify, quote, a small area of unknown function occupied by unspecified Indigenous people during the pre-contact period, and it's a hard sedimentary rock. And so Castle, not being able to afford this $400,000 fee to extract the artifacts, reached out to the Minister of Indigenous Affairs in Ontario, as well as Premier Doug Ford, and basically their offices seem to be stonewalling him. He also sent a letter to Michael Ford, who's the Minister of Citizenship and Multiculturalism that implements the Ontario Heritage Act. And the response he got was that basically no help. The determination falls within the roles of ministry officials. This is not a political decision. We can't intervene. Basically, sorry, we can't help you out. He did shop around. Castle did shop around for some other estimates. And he only was able to get one for a stage 4 assessment, which was the $400,000 assessment. And this is not the first time that this has happened in Canada. There have been other homeowners that have been shocked by high costs following unexpected and publicly mandated archaeological assessments. And there's a case that's considered precedential from 2006 when a woman named Wendy Mackay or Mackay of BC was billed $67,000 in initial costs for archaeological work and inspections because the piece of forest that she owned, she wanted to develop. There was an old house on it, and she just wanted to demolish it and build a new one. And she was billed first $67,000, and then in excess of $117,000. So she sued the province for damages for loss in her property value and the delays in constructions. And the BC, and initially her claim was rejected by the BC trial court, but the BC Court of Appeal ruled in McKay's favor and determined that the province had no authority to require McKay to pay for a heritage inspection or investigation. So I've been thinking about this. There's kind of two sort of warring principles here. The first is caveat emptor, so buyer beware. So when you buy land and beyond the sort of inspection reports and stuff like that, there is some aspect of, it's your land. So any unforeseen circumstances, or I guess historic indigenous artifacts, are kind of on you. But the rationale is different when, like, it cuts both ways. If you're going to say that you take on all the risks, then you get to decide what to do with that eventuality. Because presumably from Bruce Castle's perspective, he would be happy with just moving ahead, building his dream retirement home, and knowing that he also has this fascinating, rich sedimentary history under his soil. It's the state that's saying, no, we have a historic and archaeological interest in this, so you need to pay up to have it assessed and to have everything extracted. Mark Melke was at a conference the other week, great fellow. He's the president of the Aristotle Foundation. His opinion is that if you, as a private property owner, are forced to endure regulation that could cost you this much money, it devalues your property or could break you. And that's not a fair approach to regulating private property. He also mentions that in Europe, if the government introduces a regulation that's very costly for you, it's the burden on the government to pay for it. And he says on taxpayers. Ooh, Christine, I'm curious what you're going to think about this. He says, I don't normally recommend that taxpayers take another bill, but in this case, I think it's justified. So yeah, I think if the principle is going to be you take on the risks, then you should be able to decide what to do about those risks. But equally, I see that, yeah, the state has an interest in preserving the history and the archaeological integrity of our land. And it does seem just like fundamentally unfair if it's the state that has the interest in it, that the cost remains on the landowner. So I'll be interested to see where this case goes. What do you think, Christine? Can we have another tax added in this specific circumstance?
Well, what I would say is that this creates a moral hazard, because if you create a situation where the cost of finding artifacts is so burdensome on the individual, they might just not find the artifacts, right? Like, you might just say, I'm bringing in a bulldozer and I'm paying the guys who found the pointy projectiles, I'll pay them 10 grand to dump it instead of paying 400 grand to let the government know that I found them. So I'm not saying that that's the right thing to do. I'm just saying that if you create this costly situation that prevents someone from building a home on their own property, you have to acknowledge that you're going to cause people to make rational economic choices. And that choice in a lot of situations will result in the destruction of artifacts.
Yeah.
Josh, what do you think?
I would just say, don't take what Christine just said as legal advice.
That is not advice.
Just kidding.
Do not do that. I'm just saying that the government
I see your point.
Aware that could be a reaction to this.
Yeah. When things get that expensive, people are going to try and go around the rules. I mean, I don't even know if the government really has an interest in finding artifacts on private people's property, but it just seems absurd to me that it could possibly cost this much. And I think, something shady is going on in terms of the archaeologists and the consultants. They're probably making huge profits off of this poor landowner who's used that land before and is now, trying to do the right thing by all accounts. But it reminds me of, real estate law in law school, where they teach you, if you're going to buy any sort of rural property, before you even sign that agreement of purchase and sale, you should be consulting a lawyer, because these types of things can come up and you don't see them coming, and you end up with a property that you've agreed to buy that is, essentially worthless in some cases if it's going to cost you that much to get around the regulations
Can
and
you get
do
an
what you want with
insurance
it.
policy for that? Like, can you get indigenous artifact insurance? Oh, that's
I,
someone.
I bet you it's excluded from the common policies, but I don't know. It's a really good question. Again, consult your real estate lawyer, not a podcast. But speaking of worthless, so the other thing I'm thinking here is, there's this ancient sort of common law property law principle that if the government takes your property, they have to compensate you for that, right? Like we've talked about expropriation before on this podcast and takings, and the government generally does have an ability to take your property for certain purposes, but they do have to compensate you for it, right? So here I feel like the government's, if they claim there's an interest in having 8,000-year-old projectiles dug up from this property, which I'm a little skeptical of, but if they're getting a benefit out of that, then they ought to be the ones paying up. So I question whether this is a taking, but not something I've looked into too deeply. So we'll have to keep researching this question and see where that goes. So I think we should move on to bad legal takes. Who wants to go first? Christine, want to take it
I
away?
can go first. Mine is really gross, guys. FYI.
Ugh.
So my
Trigger
my
warning.
Yeah.
trigger warning. My bad legal take relates to this weird story about Wasaga Beach, which is a beach town in Ontario, just north of Toronto. And allegedly at Wasaga Beach, people have been pooping on the beach. And this lady on TikTok named Natty Lynn, she lives in Wasaga, right by the beach, and she posted a series of TikTok videos about how people visiting the beach, so not residents of Wasaga, but like other people from other towns, are coming to the beach and pooping on it. And they're burying their poop, and they're also burying dirty diapers. And she said she's caught people doing it and yelled at them. And then her daughter has dug up really gross stuff like this while playing in the sand. And she said some people set up tents on the beach that are kind of like, outhouses, and they put the tent up and then they dig a pit in the sand inside the tent, and then they poop in the pit. And she said that her daughter's friend fell in one of these poop pits.
Ew.
And yeah, I know, it's really gross. So she said that people who are doing this are Indians and or immigrants, like in East Indians. And this resulted in a bunch of claims that she is racist. And she's responded to these claims that she's a racist by saying that she is Indigenous herself and that her daughter is half Indian, like East Indian, and her daughter's father is Indian. And she said that she doesn't have any particular care about who is doing it. Just she's just saying what her experience is and calling out unhygienic behavior happening in her backyard so that she can warn other people so other people don't fall in these poop pits. Now, I don't know if people are pooping on the beach at Wasaga, and if they are, I don't know who they are. The mayor of Wasaga Beach has said this is misinformation and that there isn't poop on the beach. But former bylaw officers interviewed have said that there is poop on the beach. So I don't know what's true, but my bad legal take relates to what happened next. So Natty says that after her TikToks blew up, there was province-wide coverage of the beach pooping issue, and then one day police showed up at her door, and she actually recorded the interaction with police. It was an OPP officer who came to her home. She let him into the house, and he told her, and I'll quote what he said, someone called in about someone posting things on TikTok about East Indians pooping on the beach. And he said that there have been no incidents of pooping on the beach recently, and that it's an old incident. And she said, no, it's recent. My daughter's friend just fell in one of these pits. My daughter has dug this stuff up. I've caught people pooping on the beach. And the police officer said, quote, maybe don't note the particular race of the people who are pooping on the beach. And she said that she's entitled to speak about her experience and that she's not racist and her daughter is Indian. And the OPP said instead she should just encourage people to call bylaw which she already has been doing, obviously. So my bad legal take goes to the police. I mean, the officer, from the interaction, he was nice and respectful, but police should not be going to people's homes to chastise them about what they post on social media. It's a really troubling interaction to me. And it sort of shows an operationalization of our concerns around Bill C-63, which I've already referenced in this podcast. That's the online harms bill. It shows people are willing to weaponize concepts of hate speech. Like, this is clearly not hate speech. But some people don't know what that means and they call the police anyway and send the police after this woman because they don't like her TikToks. So my concern is, this is already happening without C-63. If C-63 is passed, would Human Rights Tribunal bureaucrats or Human Rights Commission bureaucrats be investigating this woman and taking her to the tribunal to defend her comments that people are pooping on the beach? And frankly, if what she's saying is accurate, this is actually a very important information. We don't want our kids falling in poop pits on the beach. We want to know the truth. And look, the mayor has said that this is misinformation, but obviously the mayor is also interested in trying to make sure his town doesn't have this reputation so people continue to visit it. So I actually think it's important information if it's accurate. And either way, the police should not be doing this. Like, this happens in England where the police show up to knock on people's doors to, chastise them about non-criminal things that they have done. Like, leave people alone. This is not a police issue. Anyway, Josh, what's your bad legal take this week?
My bad legal take goes to Amnesty International, which has named a Wet'suwet'en chief named Adam Gagnon, or I'm not sure if that's how you pronounce it in BC, but anyway, Adam Gagnon as their first prisoner of conscience. And he's serving a 60-day sentence for interfering with the 2021 construction of the Coastal GasLink natural gas pipeline in northern BC after allegations that he and others seized and disabled heavy equipment and blocked the road to the pipeline. And the actual sentence is for contempt of court. And I don't actually know the details, but sometimes that means the court's ordered protesters to stop blocking construction, and they've ignored that order. So that might be what happened here. Interestingly, Gagnon's case or his sentence is actually just house arrest. It's not even jail, unlike what Tamara Lich faced after the Freedom Convoy protest when she allegedly breached her onerous bail conditions that basically removed her right to freedom of speech. So I would say she was more of a prisoner of conscience. And the reason I think this is a bad legal take is just because it cheapens the whole concept of conscience rights. To suggest that a particular person has been denied their conscience rights just because they're not allowed to, participate in the blockading or sabotaging of a pipeline that's being legally constructed after many years of consultations and court battles confirming its legality is, like I said, cheapening the concept. And I've been researching conscience rights a little bit lately. And the point is, it protects deeply held moral convictions because sometimes the official morality of the state ends up being wrong, and people do need space to, speak out and make their conscientious objections. But it doesn't protect an unlimited right to manifest conscience in every possible way, since we all have conflicting views about what's right and what's wrong. And what it really means is the government needs to consider people's conscience claims and try to accommodate those conscientious objections as much as possible. It's not a veto over everyone else. And like I said, there's so many serious conscience violations happening in Canada that I think Amnesty could have chosen to support someone who wasn't so obviously, breaking the law. So that's my bad legal take. Joanna, let's hear yours.
So my bad legal take of the week goes to Charlotte Dalwood, who writes in The Rabble, "It's time originalism came to Canada," and she makes a case, or tries to make a case, that originalism can and should be leveraged to achieve progressive legal wins in Canada. And let me just take you through her argument. So she starts by saying that, for example, Section 7 and many of the other provisions in the Charter, so Section 7, which protects deprivations only in accordance with the principles of fundamental justice, and phrases like life, liberty, and security of the person. She points out that these phrases had very little precedent in Canadian law prior to the drafting of the charter, and she infers that this is because the drafters of the charter wanted to delegate to the judicial minds, and concludes that Section 7 was, in the minds of the people who drafted it, a quote-unquote constitutional blank check. So when you do originalist legal interpretation, you tend to look at the original public meaning, and that usually involves looking at legislative debates. And we know that Section 7 was intended explicitly by Pierre Elliott Trudeau and the other drafters and the other signatories to protect procedural and not substantive due process. This is my sort of gloss on her argument. But let's get back to her argument, because she is correct that the procedural versus substantive due process protected in Section 7 was pretty much immediately thrown out the window in an early case decided under the charter called the BC Motor Vehicle Reference, which says that basically, even though we know the debates say it protects only procedural due process, there's democratic legitimacy in giving full effect to the charter rights. So we're going to say it protects substantive due process as well. But then Dahlwood goes on and she concludes that the charter can be a bedrock protection for the right to abortion. And she says we should be originalists, not because the Constitution was perfected with the creation of the charter, but because fixing the meaning of the constitutional text in the past means that while the Constitution can never mean more than what it meant at the time, nor can it ever mean less. So it seems to me she's trying to have it both ways. She's saying on the one hand, Section 7 and other provisions of the charter are a constitutional blank check. They have no fixed meaning. It's entirely up to judges to decide what it means. And she's also saying, but it does include the right to abortion, and it can never go below that. So I must admit, I'm not following the logical corollaries that Ms. Dahlwood is trying to make. It doesn't make sense. So it gets my bad legal take of the week pick. But good try. It was an interesting, novel argument.
All right, so that's the show. For regular listeners, please go to our website or the show notes and fill out our Not Reserving Judgment survey so we can know what you like and don't like about the show. And last month, July, was actually our best month ever, Joanna and Christine. I don't know if you know that, but listens are way up, which is unusual for the summer, so good for us. You can support our work by subscribing to the CCF's YouTube channel, by following us on Twitter, or by visiting our website, theccf.ca, where you can sign up for our new and improved Freedom Update newsletter. The CCF is a nonpartisan legal charity funded by your donations, so please click that donate button on our website if you can. Thanks for listening.